Good morning.
Good morning, Ahmed. How are you?
Fine. I'm just waiting for you, Salman. I think we are missing the third judge, Ammar.
Yes.
Okay, I think we can start. Then we will see how Ammar will be joining this session. Are you fine with this?
Yeah, I'm fine if we can start on those grounds.
Okay. First of all, I would like to welcome all the students who are attending today this session. And as it appears on the screen that Judge Salman and I will be running this session, and we are waiting for Mr. Ammar if he will be joining us later on. So today we have St. Joseph representing the respondent, and we have Middlesex Dubai Group M, and they are representing the appellant. So just we will go to check the names for who is the senior appellant and the junior appellant. So I will call the name, and let me see who's here. Madhab.
Yes, Your Honor. Good morning.
This meeting is being recorded.
Madhab.
I would act as the senior appellant for.
Madhab, can you just increase the volume of the voice? I can't hear you well.
Sorry, Your Honor. Is it more audible now?
It's okay. So you are the senior appellant.
Yes, Your Honor. I'll be acting as a senior appellant.
Okay. Who is the junior?
It is Friana Guster for the session.
Brian. Okay. So. Okay. St. Joseph team. Alia Al-Marzouqi.
Yes, Your Honor.
So
I'll be acting as the senior respondent.
Okay, and who will be the junior one?
Layla Al-Isa.
Layla Al-Isa.
Yes.
Okay, so as all of you are aware that this is the session which now is the last session in the preliminary ground, and then we will go for the quarter final, and then to the final, semi-final, and then final. So as you know, this will last 90 minutes. Each team, they have 45 minutes, and I would suggest that to manage the time, because we don't want to exceed the timeline. As all of you are aware, that in the end of the session, the judge will be going to the judge room for finalizing the scoring. And I think you will start now with the senior appellant. So, Madhab, are you ready to submit your submission?
Yes, Your Honor. At court's discretion, the appellant is ready.
Yes, go ahead, please.
Thank you. Good morning, members of the bench. I am Madhub Chaturvedi, appearing on behalf of the appellant, Mr. Leith Payne, and I shall be addressing the first ground of appeal referred to this court, along with my co-counsel, Friana Gazda, who shall address the second ground of appeal referred to this court. Your Honor, my client, Mr. Leith Payne, had entered into a contract with the respondent, Ms. Rajrani, to trade in a cryptocurrency called Yapple on an online trading platform, namely the Clevity. Clevity as a platform allows users to engage in algorithmic trading and requires them to have a minimum cash balance of US dollars 50,000. As a platform, Clevity operates on blockchain technology with its nodes located worldwide. One such node among the hundreds is located in the DRC premises. Regarding the algorithmic trading aspect of the platform, the appellant uses program Beta to offer to sell Yapple at the average price of all the sellers in the market, and in the absence of all the sellers, it offers to sell at an inflated price to earn a better profit. The respondent's program Alpha, is designed to buy Yapple at the best available price. During Clevity's regular maintenance sessions on 10 June 2022, the programmers in error increased the minimum cash margin from 50,000 US dollars to 200,000 US dollars. As a result, the only two users on the platform with a cash margin of over 200,000 US dollars were the parties to the dispute. The error, although the error was rectified within 30 minutes, during that window, the programs Alpha and Beta autonomously concluded a contract to sell Yapple at 250,000 US dollars. It is undisputed between the parties that the trade was concluded at 250 times the prevailing market values. It must be noted that when the trade took place, the parties were asleep and ignorant of the activities happening on the Clevity platform. Additionally, Clevity automatically settled this trade and transferred the relevant coins and monies to the respective parties. It must also be noted that none of the parties reside in the DIFC. The appellant resides in the Sultanate of Oman, and the respondent resides in Dubai, outside of DIFC. If it may please the court, the appellant would like to begin its submissions. Would like to support the first ground that the court of first instance had erred in determining that it does have jurisdiction to hear this case based on two submissions. Firstly, the relevance of the node placed in DIFC shall be considered. And secondly, the interpretation of Article 5A1B of the Judicial Authority Law shall be discussed. Beginning with the first submission. upon the relevance of the node in the DIFC. Regarding the node is part of a distributed ledger system. A distributed ledger system is a decentralized system of nodes in a network which support the recording of encrypted data over the nodes in the network. This definition is backed up by the Dubai Financial Services Authority Glossary Module, version 54 of May 2022. Each node on this network is meant as a processor of information, which facilitates exchange of information regarding transactions happening on the network. This definition is supported by paragraph 29 of the UK Jurisdiction Task Force's legal statement on crypto assets and smart contracts. Furthermore, it is internationally accepted that the presence of a node in a country or in a premise does not give jurisdiction to that premise's courts. The Council shall refer to the case of Alibaba Group Holding Limited and Alibaba Coin Foundation of the Southern District of New York State in 2018, where the New York court held that presence of a host of a website did not give personal jurisdiction to the New York courts to hear that case. This case analogically applies to the current one, being that a host of a website is very similar to a node of a blockchain technology, as both of them are processors of information.
Madhab, do you hear me?
Yes,
Madhab,
Your Honor. Sorry.
Okay, can you repeat regarding the jurisdiction of the host again?
Yes, Your Honor. The point made by the appellant was that the presence of a node in a location does not provide jurisdiction for the courts of that area. The case referred to by the appellant was the Alibaba Group Foundation and Alibaba Group Holding Limited and Alibaba Coin Foundation of the New York District Courts in 2018, where the court held that the location of a host of website did not give the court personal jurisdiction to hear the dispute, which is very similar to the case at hand, because a node of a network acts in a very similar way to exchange information as does a host of a website, because websites are based on a central service located in most likely where the head office of the operation is. At present, there is no information about Clevity's head offices or where it originates from. Hence, the node present in the DIFC does not provide jurisdiction to the DIFC to hear this case. Hence, concluding that the Digital Economic Court judge had erred in its conclusion regarding the presence of a node.
So Madhab, but can you hold on here, please? So according to what you are saying, that you are approving that this transaction happened through the node in the DIFC. Are you approving this?
Yes, Your Honor. The council approves of that.
So
however,
you don't have any objection that it's happened through other nodes around the world?
Yes, Your Honor. The operation of a distributed ledger system is as such that the transaction is entered into the network through any of the nodes. However, the node only acts as a mere exchanger of information, rather than being a place to finalize or conclude the contract as referred to in Article 5A1B of the Judicial Authority Law, which in the next submission, the council shall refer to as stating that any contract which is wholly or partly concluded, finalized or performed or is to be performed in the DIFC will provide a jurisdiction. In the current case, a node in the network of a distributed ledger system does not act as as a place of finalization of contracts within, and as it acts as a mere exchanger of information, this does not provide jurisdiction to the DIFC to hear this case.
So Madhab, just answer me regarding this question. When Clifty they started to work within the IFC jurisdiction, I guess that they signed a contract with the IFC authority to be operating their node from their jurisdiction. So if I am saying that signing this contract between the IFC and Clifty is part of this transaction, how you can argue this point?
Your Honor, if the presence of a node started providing jurisdiction to that area, to the courts, the location of hundreds of nodes worldwide would start providing jurisdiction in all those countries where the nodes are located, opening up floodgates for jurisdiction shopping and users and entering into claims around the world and in courts of their choice. Hence, this was the analogy given by the Alibaba case, where analogy given by the Alibaba case and restricting the floodgates of allowing a host of a website to provide jurisdiction. Hence, the similar analogy should be applied to the current case by concluding that the node does not provide jurisdiction, else users will begin entering into claims worldwide. Yes, Your Honor.
My co-judge is asking a specific question. The analogy that you're drawing from Alibaba case is with regard to a specific website. There is a difference between the node of a website and the node of a distributed ledger. Also, he has specifically highlighted the contract that is being entered between the IFC and the website. So in this case, it is what he's saying is when they are entering into a contract, they, by entering into that contract, agree to that jurisdiction because they have specifically signed that agreement. In case of a website, that is not happening because website can be hosted in any jurisdiction. There is no contract between the website and where that website is hosted. You understand?
Yes, Your Honor. If I correctly get the gist of the question, in response to that, the present Clevity has surely been in contract with the DIFC to place its node in its premises, of course. But rather, the current dispute is between two parties residing in the Oman and in Dubai. The node
So
the contract.
This argument on yours, it is with regard to this argument that he had highlighted that there is a specific contract entered between DIFC. When you are entering into a specific contract, say for example, setting up an office. So under that contract, when you are agreeing to the laws of DIFC, because generally in the contract, there are provisions relating to the jurisdiction. So you are agreeing to that jurisdiction. So the analogy that you are drawing with Alibaba case is a little different. And the question of my co-judge is a little different. You understand? Because the website, anywhere in the world, they don't have to enter a contract to give the address of that particular place where the website is based. But in case of a node in this distributed ledger, they have entered into a specific contract to base the node in DIFC, and hence they are agreeing to that jurisdiction.
Your Honor, at present, the facts do not state that that the contract entered between the Clevity platform and the DIFC gives jurisdiction, though there are certain terms and conditions stipulated impliedly into the disputed trade. However, the only agreement on jurisdiction between the parties was that if the DIFC has jurisdiction, the DIFC laws will apply. Except of that, there has been no agreement between the parties regarding the jurisdiction of the case. The only jurisdictional matter comes up when the first instance code refers to Article 5A1B applying the Al-Khurafi Bank and Saraceni case in providing jurisdiction regarding stating how the node as a location of finalizing the contract and giving jurisdiction. The contract between the Clevity and the DIFC has not been indicated in the facts of the case.
Okay, you may
Okay.
proceed.
Yes, Judge Salman, please. Go ahead.
No, I was just asking him to proceed. Sorry, please go ahead, Ahmed.
Thank you. That's okay. You can proceed because the time is running and we want to just manage the time. Yes, please.
Yes, sure. In the light of the time remaining, I shall conclude the first submission, moving to the second one, regarding how the Article 5A1B must be interpreted with the other laws of the DIFC regarding the application of DIFC laws upon commercial contracts. The law number 10 of 2005, law number 10 of 2005 guides on how the DIFC laws will apply on commercial contracts, and specifically Part 5, where Article 16.5 stipulates 3 tests to establish jurisdiction of a contract within the DIFC. The tests in subparagraphs A, B, and C will fail as the parties lack an express option of the jurisdiction of the case. There is lack of evidence regarding the physical address of the parties' accounts on the Clevity platform. Also, that Clevity's head office is unknown to the parties. Thus, failing these 3 tests, the DIFC law number 3 of 2004 is applied, which provides guidance on general jurisdiction of the DIFC courts, under which Article 8.2 stipulates 5 criteria to establish jurisdiction. Criteria A, B, and C are likely to fail as the parties have not expressly agreed on the jurisdiction in any respect of the dispute. Hence, the close connection test in paragraph D shall apply. Regarding the close connection test, the Canadian Supreme Court in Imperial Life Insurance Corporation and Colmenares case of 1967 states that the residence of the parties is an important criteria to establish close connection. As it must be recalled that the parties reside in Oman and outside of DIFC respectively. Thus, it is concluded that DIFC does not have jurisdiction to hear this case.
Madhab, can I ask you something, please? Now you are trying with your submission to deny the jurisdiction of the DIFC. But let me just take it from the different way. Clevity, they operated from somewhere in the world. They have a node in the DIFC. We have a party in Oman and a party in Dubai. Did you ask yourself why they establish a node in the DIFC where they can do it from any other part of the world? They don't need it to establish here in the DIFC. What's the purpose of establishing this node in the DIFC?
Your Honor, the purpose of establishing a node in the DIFC it depends on the intention of the Clevity platform. It can only be inferred that the intention may be to use the Dubai infrastructure for its internet capabilities and capabilities of information technology. Hence, presence of a node in the DIFC may not have a direct inference on the intention of Clevity to establish jurisdiction of international parties. As you rightly mentioned, the node could have been placed anywhere else in the world, anywhere else in the Gulf region, but why the DIFC? This shows the DIFC's high-level infrastructure and capabilities for information technology and internet connectivity. Hence, the Clevity's decision to place a node in its premises.
So, Madhab, DIFC is a part of the Greater Dubai, the mainland, and it's a free zone, financially free zone. So, if you are saying regarding the internet infrastructure is advanced in the United Arab Emirates, in particular in Dubai, so they can locate this node outside of the DIFC jurisdiction. But by choosing the DIFC jurisdiction, there was a purpose and intention for that. do you think this is the point can be discussed?
Yes, Your Honor, this point can truly be discussed. DIFC being a free zone is outside the domestic federal laws of the Dubai courts. Hence, DIFC can have its own jurisdiction as being outside of Dubai. Thus, placing a node, as I must refer again, does not directly infer the Clevity platform's intention of giving jurisdiction, as the facts do not state any indicate on in this regard.
Okay, Mithal, you can continue, but I think you will have 4 minutes because you have your junior, and I think senior respondent then. Okay, you can go ahead. Yeah, you can go ahead.
Yes, John. In light of the time, I would like to conclude on my submissions. With this, I shall end the second submission made regarding the interpretation of Article 5A1B of Judicial Authority Law, and conclude by saying that the presence of a node in the DIFC does not substantiate the first instance court's argument of the disputed contract being concluded, finalized, or performed in the DIFC. Lastly, the court must interpret Article 5A1B of the Judicial Authority Law alongside other DIFC laws which guide on the application of DIFC laws upon commercial contracts and contracts in general. Thus, hence concluding that the first instance court had erred in stating that the court DIFC has jurisdiction to hear this case.
Judge Salman, do you have anything to add on this part, please?
No, Judge Ahmed, I think that's fine.
Thank you. Unless any further questions, the appellant shall end its submissions. Thank you.
Thank you for your submission. Now we will just start with the senior respondent, Senior Alia Al-Marzougi.
Yes, Your Honor.
Yes, Alia, you are acting as a senior respondent, and yes, Alia, you can start your submission.
Okay. May it please the court, my name is Ali Al-Marzougi, and I represent the respondent, Mrs. Raz Rani. I would be responding to the appellant counsel's arguments regarding jurisdiction. Would Your Honor like me to go over the background of this dispute?
Yes, Alia, but I would suggest to summarize the background because you have to also manage your time.
Okay. I'll just cover the relevant facts. My client and the appellant, Mr. Payne, are both users of the Clevity platform. Clevity operates through a distributed ledger that is hosted across hundreds of digital nodes in many countries across the world. One node is on a server based within the DIFC. My client resides in Dubai, the UAE, therefore she issued proceedings in the DIFC courts. On the 10th of June, and under the circumstances of the routine upgrade, where Clevity excluded members that had less than $200,000 instead of the intended $50,000, my client and the appellant were the only two users to be able to trade until the glitch that happened in the routine upgrade was detected and rectified. My client, with the absence of other market activity, my client's program automatically bought YAPL, which is a cryptocurrency on the platform, from the appellant at a highly inflated price, which is 250 times greater than the prevailing market price. My client, therefore, issued proceedings in the DIFC courts, Digital Economy Court, seeking a declaration that the disputed trade was void for a natural mistake. The first court instance judgment was in favor of my client regarding jurisdiction and regarding the mistake. The appellant appealed, trying to reverse the judgment of the first court instance. Therefore, I would be responding to his application regarding jurisdiction. We would like to take this opportunity to present the grounds that establish the jurisdiction of the DIFC courts. Going back to Article 5A1B of the Judicial Authority Law, it provides that civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the DIFC, or will be performed or is supposed to be performed within the DIFC pursuant to express or implied terms stipulated in the contract. Because the platform Clevity operates through a node placed within the DIFC, I would like to take this opportunity to explain a little the role a node plays in a blockchain. A node doesn't only host, but it also secures, encrypts all the transactions done on the platform. So each node works as a mirror for the other, which means that each node hosts the whole transaction. So having a node placed in the DIFC makes the contracts wholly, if not partly, concluded within the DIFC. Under the jurisprudence of this court, quoting Al-Kharafi versus Bank Saracen precedent, the essence of the provision is that the court is given jurisdiction where there has been relevant activity in regard to contract or related to it within the DIFC. As regard to the essential role a node plays in hosting, securing, encrypting transactions, a node placed within the DIFC is enough to say that there has been a relevant activity within the DIFC, confirming the jurisdiction of DIFC courts. In another common law case, in Retezos versus litigation, it was the first case to consider the location of a node to determine the jurisdiction of courts. This affirms, Your Honor, our argument regarding the location of a node in determining the jurisdiction of the DIFC courts, and that the disputed trade was a result of an error. To conclude, Your Honor, we need to determine that under DIFC courts, the Digital Economy Court would be competent under Article 58.7 of the DEC rules. For foregoing reasons, we respectfully request the court to reject the appeal of Mr. Payne and confirm the first instance court's decision and take the actions needed. Thank you, Your Honor.
Alia, let me ask you something. So how can you approve that the transaction happened through the node hosted in the DIFC? It could be done through any other nodes, hundreds of nodes around the world. What's your proof that it has happened through this specific node?
Because, Your Honor, a node transaction doesn't go just through one node. Transactions go through all nodes. So to say that it might have been made under a different node or the transaction has gone through different nodes across the world would defy the definition of a node, because a node in a blockchain or in a network is a mirror to every other node placed in different countries, which means that the transaction doesn't only go through one node placed in a certain country, it goes through every single node, which means that the transaction was hosted on the node placed within the DIFC.
So, Judge Salman, do you have anything in this regard?
Yeah, I specifically wanted to ask with regard to, since you say that the node is a mirror of other nodes and thousands and millions of nodes hosted elsewhere. So wouldn't that dilute the jurisdiction concept? Because if there are mirror, then it could be the jurisdiction could be anywhere else in the world. How do you justify that it is specifically hosted in the DIFC? Or the jurisdiction would be concluded in DIFC?
Of course, jurisdiction might be given to different nodes as well, because every node acts as a host that secures and encrypts transactions that is going through the platform in a certain network. However, that doesn't also defy that this one single node or that this node has jurisdiction and has the right to give jurisdiction to where it is located. Since as a node, it still holds all transactions. It is still important in the chain. It is just like every other node placed in other countries in the world.
So what you are saying is basically that since the various nodes are identical to each other, the fact that the jurisdiction could be concluded elsewhere can also be concluded in DIFC. That is basically your argument.
Yes. Also, Your Honor, I would like to bring up a case that we have attached in our correspondence. It is in Retezos litigation, which I have mentioned in my submission. this case, Your Honor, considers the location of a node when giving jurisdiction to. This was the first case to actually give to consider allocation of a node when giving jurisdiction to specific courts. So I think based on such case,
what is
and Retiso's litigation, Your Honor.
okay?
Okay, thank you, Judge Salman. Alia, do you want to add anything before we shift to the senior appellant?
Nothing to add, Your Honor.
Thank you, Alia, for your submission. I think the time now is for the senior appellant. Madhab?
Yes, Your Honor. In an attempt to provide a rebuttal to the points made by the senior respondent, the appellant shall address it in two parts. Firstly, the point made that a node is a mirror of other nodes, and as rightly mentioned by Judge Salman, that this would reduce the concept of jurisdiction. The senior appellant shall restate its point regarding the jurisdiction shopping and how the presence of nodes worldwide gives jurisdiction provides an opportunity to users to bring claims in any country where the node is located, hence enabling them and hence opening floodgates and essentially reducing the users choosing which laws facilitate them better and which laws don't, which would be prejudicial to the defendant of the case. In this regard, with this, the point made that a node is a mirror is undermined by the fact that the opening of floodgates is an issue for the judicial systems worldwide. And additionally was the point made by the Alibaba case regarding the floodgate openings. Secondly, over the point made that a contract is concluded on the node in the DIFC, hence it provides jurisdiction to the DIFC. A hypothetical situation must be provided to the courts in this regard is that imagine if the node in the DIFC was unplugged by someone, say by the janitor of the DIFC, by mistakenly unplugged the node. Would this unplugging take away the jurisdiction of the DIFC? As referred to by the senior respondent, the presence of a node and the working of a node, finalizing and concluding the contract gives jurisdiction to the DIFC to hear the case. Say the node was unplugged and unoperative, does that take away the jurisdiction of the DIFC? Is the jurisdiction of DIFC so light that it is dependent on the working of a single node? Hence, with this, the senior appellant shall conclude its submissions. Thank you.
Madhab, once again, to your point, and I heard this unplug yesterday from someone else, and I don't want to come in this argument again. It's long debate. What I'm saying now in this point that a node located in the DIFC, and I said for you, the parties in Oman and Dubai, Clifty has an intention to establish a node, which is computer, doing processing so many things, and you need to prove that node is not involved in the transaction or it doesn't have effect in the transaction. So what about if the respondent is saying that Clifty established this node in the DIFC on two elements. The first element that, as you said, the internet infrastructure in Dubai could be one of the best in the world, and it could and should help the traders who are located in that's supposed to say GCC countries, because for each country specific security requirement and specific compliance. So some transaction which is accepted in other jurisdiction, it might not be accepted in this jurisdiction. Bear in mind that there is other Dubai laws which also has some ties to the DIFC laws indirectly, which DIFC laws also have to look at these bundle flows. So I would say for you as a Netflix, which they are operating here in Dubai, the platform is different than USA, because for each country they have their own rules and regulations. So since Cliff TV has hosted a node in in Dubai in particular, so bear in mind the point which I raised. I don't want to repeat it again. On the other hand, that a DIFC is a common law jurisdiction, which is an international system or legal system or regime. So if someone will argue with this, that hosting a node in DIFC by Clifty, there's an intention or there is a purpose of that to just provide the infrastructure at the time of the dispute. So how you will answer this?
Your Honor, upon the first part of the question regarding how the node in the DIFC is useful for processing information over there, it must, and how it's, as the example provided of Netflix, how it is different in the USA as compared to in Dubai. As rightly mentioned by the senior respondent, that a node is a mirror of all the other nodes on the network, thus stipulating that the node in the USA will not work differently as the node in the DIFC. Hence, the operation of a node, and I must restate my point from the US Jurisdiction Task Force's legal statement on crypto assets and smart contracts, where in paragraph 29 they state that a node is a process of information and is a means of information exchange rather than a place of concluding contracts. And in regards to the different laws of the different areas, the laws of the DIFC may apply if it has jurisdiction to hear this case, surely, and that is the agreement between the parties. But in the present case, the DIFC does not have jurisdiction, as was contended by the senior appellant. Upon the second part of the question regarding my apologies, Your Honor, if you may please repeat the second part of your question.
I was saying that there's two parts in this point. Using the legal system in the DIFC, the common law regime.
Yeah, so regarding the common law regime, common law is the New York Supreme Court judgment on the Alibaba case was also a common law decision, where it held that a presence of a node does not give jurisdiction. Hence,
Madhab, please, can you hold on, please? I'm not saying that referring to Alibaba as my as the co-judge, Mr. Salman, he just mentioned. I will not repeat his point again, but I'm saying that Clifty, they want to utilize the courts in the DIFC, which are practicing according to the common law. The common law is the international legal system regime, which make all satisfy to use it and easy. So there wasn't some sort of things when Clifty operated or they hosted the node in the DIFC that they might dispute will raise through their platform, and the DIFC will be the best jurisdiction and the best mechanism for them. Why they didn't do Madhab, on the other hand, why they didn't operate it in the mainland, in the greater Dubai, which will be better for them. So they have to choose the DIFC, and there is a course in the DIFC on the other side, practicing common law. What do you think there's a tie between these two things?
Your Honor, a tie can certainly be inferred from the facts of the case. However, there hasn't been any evidence of such intention of the Clevity platform in using the node to give jurisdiction. Additionally, yes, Your Honor.
Have you reviewed the terms and conditions on the Clifty platforms? Have you seen what is there?
Your Honor, the council does not have access to the terms and conditions of the Clevity platform. Hence, from the facts available to the council, it is there is no evidence of Clevity's intention of having the DIFC of giving DIFC the jurisdiction to hear the case. Hence,
Suppose the terms and condition on the platform, it's indicating to that any dispute will raise by the transaction happening on this platform, the DIFC courts will be the dedicated courts. What you will say
in that case, Your Honor, the case of the senior appellant totally fails, as the terms and conditions have clearly stated that the DIFC has jurisdiction, and at present, in the absence of laws, in the absence of international laws which govern cryptocurrencies and crypto assets, the terms and conditions of the Clevity platform will be the most authoritative source for the court to have its jurisdiction, and the senior appellant would have totally failed in that case.
Thank you, Madhab. Do you want to add anything in this regard?
No, Your Honor, that will be it. Thank you very much. Except the pleading to the court to uphold the appeal to the Court of Appeal. Thank you very much.
This has been received. Thank you, Madhab, for your submission. Now we are going to hear the junior appellant. Layla Isa.
No,
I'm sorry.
Your Honor,
I'm sorry. Piriana.
Yes. May it please the court, as previously introduced by my learned senior counsel, Mr. Mother, my name is Triana Khassa. I will act as the junior counsel for the appellant, Mr. Lee Spain. Your Honors, I will address the second ground of appeal and attempt to convince this court to invalidate the decision of the judge in the court of first instance and further support the argument of my co-counsel as a result of this confirming that in the case of Raz Rani, the respondent, and Lee Spain, the appellant, the court conclusion based on the reasonable man test was incorrect. On the basis that a unilateral mistake cannot invalidate the disputed trade since the appellant did not have constructive knowledge of the respondent's position, this submission will be made opposing the respondent's views. The second ground of appeal implies that did the first instance court error in concluding for the purpose of a claim to avoid the disputed trade, it would be sufficient for the purpose of satisfying Article 37(1)(a) of DIFC contract law that Ms. Razi shows a reasonable trader with knowledge of circumstances surrounding the transaction could have concluded the trade, disputed trade was a result of an error. In this case, Your Honor, I would like to present my submissions in response to the second point of appeal, which was mentioned above. If it may please the court, I will now proceed with my submission.
Yes, please go ahead.
Your Honor, thank you. Your Honor, the first instance court did error in concluding for that the claim to void the disputed trade because it is sufficient satisfying Article 37(1)(a) of the DIFC contract law. The respondent shows that a reasonable trader with knowledge of circumstances surrounding the transaction could have concluded the dispute was a result of an error. In other words, it is not sufficient to show that the appellant was a reasonable trader had it had constructive knowledge of the mistake, which Mr. Lee Spain did not have. Instead, the court should have examined the programmer's state of mind when designing the program. Article 37(1)(a) of the DIFC contract law clearly states that the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to the reasonable commercial standards of fair dealing to leave the mistaken party in error. Therefore, based on Article 37(1)(a) of the DIFC contract law, there cannot be relevant mistake. Even if the respondent made a mistake when the appellant, Mr. Lee Spain, had programmed better, he did not make the same mistake as the respondent, Ms. Razi, or cause her mistake, as he did not know and could not have known about her mistake. Hence, no grounds to avoid the disputed trade could have taken place. Therefore, moving on, we can look at if the court considers the reasonable man test, any reasonable trader who regularly undertook the algorithm trades on the Clevity platform, like the appellant, could not have known and would not have developed any awareness or sense that the sale of the apple was higher than the market price and it was an abnormal situation. Thus, it is contended that the contract is still valid. The point above, which I just made, is supported by applying the majority of the Court of Appeal's judgment, compromising of Chief Justice Sundareshwar Menon Andrew Fang Boon Yong, the judicial assistant, Judh Prakash, another judicial assistant, and Robert Sheldon French, in the view of the case Coin Pte Limited versus B2C2 Limited 2020 in the Singapore Court of Appeal. The disputed trade shall not be reversed and the respondent's claim should be dismissed. Would Your Honor like a brief overview of this specific case?
Yes, please go ahead.
Thank you. So B2C2 had entered into a membership contract with Coin under B2C2 could make any trades of cryptocurrencies with other counterparties on Coin's automatic cryptocurrency trading platform. B2C2 initiated trades on a cryptocurrency in exchange of Bitcoin, another cryptocurrency on the platform. However, due to this entire program malfunctionality, which had consequences could not be anticipated by Coin, the platform executed B2C2's trades at an exchange rate of approximately 250 times than the current market rate in favor of B2C2. However, B2C2's account was automatically credited with the proceedings of this trade. So what we're trying to state is when Coin's chief technical official later on manually reviewed the trades, he considered whether this was a result of an error, he reversed them. And notwithstandingly, the membership contract provided that the trades were irreversible, meaning if any contract took place on this platform, you can't reverse it because the trades in the membership contract says it's irreversible. Therefore, B2C2 brought an action against Coin, claiming in reversing the trades. Coin's actions were a breach of the contract between B2C2 and Coin in relation to participating on the platform. Hence, Coin was in breach of trust. The court ultimately found in B2C2's favor and stated that in reversing the trades, Coin had breached its contract with B2C2 and Coin failed to establish a mistake that would make contracts for this trade void. As a result, it also held that Coin was in breach of trust. Furthermore, Your Honors, if we use the case of Coin, it can be stated and it can be seen that the judges held that the contract in respect of each concluded trade was made directly between the buyer and the seller. Therefore, Coin's unilateral cancellation of disputed trades was a mere breach of agreement. The aforementioned decision can be adapted and established to the current case of the respondent and the appellant, Mr. Leith Payne. If we further go below, we'll be able to understand that by relying on Mance LG's reasoning in Coin, the first instance court erred in rejecting the appellant's claim. Instead, the court should have relied above on the majority judgment passed in Coin. As Article 37(1)(a), it is undeniable that the disputed trade took any domestic algorithms without human interface, thus preventing any possibility of actual knowledge on the part of Mr. Leith Payne, the appellant, due to which the appellant could not have known that the disputed trade was a result of an apparent malfunction, as the appellant's program beta was coded in such a way to sell Yapple on the platform at a price based on the average Yapple price, meaning when he's selling his program beta, it would be sold, he will sell Yapple on whatever average price is there on the platform. However, he did have a stationary edit also, which means that beta, however, could automatically offer Yapple for sale at a highly inflated price, like 250 times more on Clevity if no other users were selling Yapple. So in conclusion, Your Honors, it is a submission of the appellant that the judge erred in rejecting the appellant's claims for the reasons stated above. And as the contract was legitimate and not governed by DIFC, the claim should have succeeded. For the foregoing reasons, I respectfully request the court to find in favor of the appellant and dismiss the claims made by the respondent, Ms. Rasrani. It is therefore on these grounds that we ask Your Honor to dismiss the claim. Unless I can be of any further assistance, this concludes the case for the appellant. Thank you.
Thank you. Judge Salman, do you have anything input in this regard? Judge Salman? Okay, until just we see that Salman, let me ask you something now. Regardless of the programming and what's happening on the platform and the mistake for each party, I would guess that there's the principle of effective justice, the principle of effective justice. That's the goodwill principle should be bear in mind. I will give you an example. Suppose you have a platform selling mobiles, and then I order for a mobile. By mistake, you send me 2 mobiles. This is a mistake. Through the platform, I order through the platform a mobile online transaction, and then the platform sent to me rather than 2 mobiles. So at that time, I have received 2. I can't say that this is your mistake. I will not return the other one. Or I can consider this is something beyond your control. The machine or the program made a mistake. Then I will take the decision on basis on the goodwill principles and the justice principles that to return back to you the second mobile. What you can say in this regard?
So if we look at the goodwill consideration, over here, I'm supposed to send you 1 mobile, but I sent you 2. However, Your Honor, in this specific case, Mr. Payne had already programmed his beta in such a way that if no other seller was available, they could sell it at another price, at a highly inflated price. So Mr. Payne knew what he was doing with this program. He knew that he would sell it at an average price at a regular platform. However, there was a distinctive knowledge kept aside that, okay, if there's no other person, I shall send it in highly inflated price. So he knew about that. However, whatever Miss Razi did was not according to his knowledge. So even if Miss Razi has done a mistake, it's not his authority to change that mistake because he had programmed his software in such a manner. If he had not programmed his software in such a manner and the entire case took place, then according to having humanity, he could have returned it. But in this case, he has programmed his entire software in a manner that he can sell it for a higher price. If he had not, then we could have looked at that scenario.
So you are denying that he should correct an injustice that might cause enormous harm for the other party. It's okay. So, Judge Salman?
Yeah. So here,
Yes.
what I want to ask you is, if the programs are being, they are being conducted in such a manner, and the trades are being conducted in such a manner that it is automated, and the automation is happening as per the instructions of the relevant parties. Wouldn't those actions be treated as actions taken under instructions of the relevant parties, and they be vicariously liable for those actions, even though it is a computer program that is conducting those trades? So for any party to deny that it has not been done by their consent, or to reverse the transaction, wouldn't the concept of vicarious liability apply here?
So if you look at it from my perspective, or means the appellant's perspective, that actually does apply. Because if you look at this entire scenario, Mr. Payne already knew of the fact that he could sell it at 250 times more. However, Miss Razi did not. So if you look at it, both parties knew of the risk which was entitled to come with it when you go through such a program, because it's a program which has no human interface. It's completely automated. So Ms. Razi should have known that something of this could have occurred, and she should be liable to take this into consideration. However, we don't have any liability or Mr. Leith Payne does not have any liability, because the way he programmed his entire software clearly states that he could sell it at a very highly inflated price. So I think this question would entitle and give more leverage to Mr. Leith Payne into getting what he wants.
Good,
Judge
yeah,
Salman,
that's what I was looking for. Yeah, okay, good.
Thank you, Judge Salman. So now I think we have half an hour to finish the session. I would just like to call the junior respondent, Layla Al-Isa.
Yes, Your Honor.
Yes, Layla, please submit your submission.
Yes, Your Honor, and may it please the court, my name is Layla Al-Isa, and I will be tackling the second ground on why there is a relevant mistake. Now, Your Honor, my client entered into this trade under a mistaken assumption that she was transactioning at or around the market price for Yapple. However, Your Honor, the appellant had placed to sell the order of Yapple at a price that was inflated as a result of an intentionally pre-programmed inflated price strategy. Thus, the appellant knew or ought to have known that such consequences would arise in the future, not just with my client, but with any other user on the platform. And any reasonable trader would not have concluded such trade. Your Honor, the Court of First Instance rightfully concluded that the disputed trade was a result of an error based on Article 37(1)(a) of the GIFC contract law. Now, this article, Your Honor, proves that the disputed trade between my client and the appellant was in fact a result of a mistake which was caused by the appellant. My third point, Your Honor, is that if a unilateral mistake at common law is difficult to prove, then a unilateral mistake in equity should be taken into consideration. And I say that based on the precedent Coin versus B2C2, which stated that the value of the differentiated analysis of unilateral mistake operating both at common law and in equity is that it enables the court to address in a circumstance-specific way situations where, for one reason or another, parties objectively reach agreement on a contract which, as one party knows or ought to know, differs in some fundamental respect from the other party, from what the other party thinks it is or means. Also, Your Honor, despite the principle of certainty of contracts and that the parties willingly use automated trading programs, there is nothing surprising about a test which asks what any reasonable trader would have thought or would have given knowledge of a particular circumstance. Whether the unknown activity of two computers in the middle of the night should bind the parties, it should be judged by asking whether any reasonable trader on the relevant exchange, knowing what was happening or what could have happened, or even what could have thought would happen, is otherwise prevailing circumstances. Now, Your Honor, for the reasons I just held, the Court of First Instance rightfully dismissed the appellant's claim by holding that the disputed trade was a result of an error. Thank you.
Leila, let me ask you something now. If someone will blame your client or the respondent that you should keep in consideration so many circumstances, unforeseen circumstances, such as mistakes, what happened in the beginning. So since I am programming my computer or my software, I should bear in mind all the circumstances, and this is one of these circumstances. So this is something I can say, the respondent, he has a liability in this part because he didn't take these kind of transaction and circumstances into consideration when he built the software for his program. Leila, let me see it in other way now. If you have a contract, you as a legal counsel drafted a contract, and you are representing a party in this contract, and you have missed some provision or important clauses in this contract, and then at the time of dispute, maybe your client will blame you that you didn't the quality of your performance and doing this contract was in that level. So what you can say?
Yes, Your Honor, I think it's unfair to say that because it's unfair for my client to have paid 250 times greater than the prevailing market price for Yapple. And when it's not even like 50 times greater or even 100 times greater, but a 250 times greater price than the prevailing price is unfair.
Laila, this is not about fairness. This is about the reasoning and the facts. So obviously, we understand the emotional and the ethical arguments, but unless and until we are able to support that with solid reasoning and facts, it would not answer my co-judge's question. So would you comment on that?
Your Honor, when the appellant programmed his program, when there's only one other user, if there's only one other user, it automatically offers to sell YAPL at a highly inflated price. I mean, he should have known or ought to have known that such circumstance would occur with my client or with any other client on the platform. So this error could have occurred with any other user on the platform.
And what would you say to my argument with regard to vicarious liability, which I had put across to the other party, where in terms of the programming of the trades or the way the computer was programmed to conduct trades, it was being done under specific instructions, and once those instructions are executed, shouldn't the parties be liable for the acts of the computers?
Your Honor, my client programmed her program in a way so that she could buy YAPL at the best price on the Clevity platform. However, when she traded with Beta's program, with the appellant's program, it was at a very high inflated price. So that is my point.
Okay, thank you.
So, Leila, before you just leave this part, let me ask you something. As a respondent, now you are seeking to rectify what's happening and correct these mistakes. Why are you choosing to go and sue the appellant or Mr. Paini? Why you didn't think about suing the platform, Clifty?
Because, Your Honor, Clevity just hosts the transaction. So whenever a trade occurs, it's between both parties. Clevity has no, we can say, relation to the trading happening between the users.
So you said that a glitch happened on the platform. There's a glitch happened on the platform. That means Clifty is a part of this mistake.
Yes, however, it only hosts the transaction. It does not. It's concluded on the platform. However, it's on the basis of both parties' regulations of their programs, of their computers.
But the mistake happened because of the software of Clifty. And do you think they don't have any involvement in this?
Your Honor, Clevity has a routine upgrade. What happened was a routine upgrade. It just so happened that there was a glitch. And when that glitch happened, there was only 2 other users with a margin over $200,000, and it was Beta's, the appellant's program.
Once again, I think the respondent, before he entered into a transaction, I'm giving you some general IDs. I'm not just arguing with you. Do you think it's good to have a look at the terms and conditions of the platform which hosting these nodes?
The terms and conditions of the Clevity, I don't think should be taken into consideration because, as I've said before, another term, like another contract is concluded when both parties enter into a trade.
Okay, do you think this is not relevant? It's not important, but suppose if you failed to chase the appellant and then you have option B. So if there is a way to sue the platform, it's also a good opportunity. So bear in mind that always you keep option B in your mind. Judge Salman, do you have anything to add in this regard?
No, thank you, Judge Ahmed. I think I did get my clarification from her.
Okay. So now, now the time. Do you want to add anything, Judge Salman?
No, I am fine. Thank you.
Okay, thank you. Now we have the last one, the junior appellant, Rihanna.
Yes. Thank you,
Yes,
Your Honor, for giving time for the rebuttal. So when the junior respondent was speaking, she stated initially that Naz Rani programmed Alpha, her entire program, stating or assuming that she would receive the market price. However, if you look at the facts of the case, it says the best available price. And later on, if we move on, she did correct that by saying that Ms. Raj Rani was looking at the best available price at that moment. However, at the platform when the glitch took place, Mr. Payne was actually showcasing the best available price because he was the only individual there. If we further look at the points made, we can clearly state that the inflated price of 250 times more was a foreseeable risk, because when you program such things on a platform, you will know of what would take place and what
Fiona,
should
please
be
hold
taken
on,
place.
please. Fiona, hold on, please. I was missing the connection for 30 seconds. Can you repeat what you were saying, please?
Yes, Your Honor. So, Your Honor, I was stating that when the junior respondent was speaking, she stated initially that Ms. Raz Rani programmed Alpha, assuming that she would receive the best market price. However, if you look at the facts of the case, it states that she should be receiving the best available price, and that was later corrected by the respondent. However, at that time, when an error took place on the platform, which was Clevity's fault, the best available price was Mr. Leith Payne's, because no other individual was there. And it is also not the appellant's fault that he had more than 50,000 on his platform, because there is no end result of how much you're supposed to have, but there is a start. So the mistake which happened on Clevity was a glitch, which is neither the appellant's fault. So it shouldn't be looked at upon the appellant. And furthermore, whenever you're getting into a transaction of this sort, or when you're making a program, you should be knowing of the foreseeable risks that could potentially take place. Not necessarily would take place, but could take place in the future. So I would just like to state that it is not the appellant who made a mistake, but maybe Clevity. And the algorithms that were offered to buy and sell to other algorithms, the trades can be concluded without direct human involvement. So even if only if there was human involvement, that's when the appellant could have been liable. However, there wasn't. And Ms. Raz Rani and Leith Payne were both users of this platform, and undertaking the algorithm trading of autonomous programs that were created, he cannot be liable. So it's very specific on what took place and how it can take place also, and what should have been done. But it is not the liability of Mr. Payne, as his program was coded in such a way that you could sell it at an average price, and also if there are no other users, you could sell it at a highly inflated price. So that concludes my rebuttal. If there are any questions, I would like to take them.
So let me ask you something now. I think you have mentioned that it could be Clevity mistake. Am I right?
Yes, sir. Yes, Your Honor.
Okay. So according to this, now you are saying that the appellant, he doesn't bear any liability in this transaction. However, maybe the respondent can sue Clifty as a platform because the glitch happened from their platform.
Yes, Your Honor, because at the moment we don't have any authority who's representing Clevity, nor do we know what took place and how took place in very specifics. But if that comes into light, Clevity can definitely be, contacted by the respondents, and they could be liable because the glitch was a platform glitch. It was not the appellant's glitch or the respondent's glitch.
So do you think in this practice, which we are doing now, Clifty being excluded from entering in this matter, or both parties, they didn't approach this point regarding Clifty's involvement?
So I think the reason why Clevity hasn't come into consideration yet from the appellant side is because we believe that because our program was coded in such a manner, we don't need to bring Clevity in, because our program clearly states that we can sell it at an inflated price if nobody else is available. However, if the respondents have something to go about that, because it's very specifically because of this error which took place on the platform, we're getting this case, they can go to Clevity. But we personally do not want to go to Clevity because we are very sure and we're very clear on what took place, and we are not liable in any way, and we don't want to hold Clevity liable from the appellant side. But the respondents may want to because it was their glitch and not ours.
Yeah, I can understand this part, then it's a respondent's choice to chase Clifty, not the appellant best choice. So anyhow, I would like to thank you, all of you, for what you have submitted today. And from oral, discussion and argument, it seems that both parties, they are work hard to find the evidence and the grounds, and I think now Judge Salman. You want to add anything, Judge Salman?
Yes, Judge. I think I agree and second your observations. I was very especially impressed by arguments and deliberations made by both Gulzar and also Alia, Laila Alisar. They were very articulate and very to the point. And I think both the parties have done their research and put this across. Maybe they should have referred to a little more case law and some more analogies and that. But I think overall it was a very good effort. Wish you all the best. Thank you so much, Judge Ahmed. Pleasure, Judge.
Salman, for your participating and assisting me in this. And really, your input was very amazing inputs. So I would like to thank all of the teams, St. Joseph and Middlesex University in Dubai, Group M, for being here today with us. What's happening now that Judge Salman and I will be entering the judge room for discussing the scoring. And by this, we are announcing the closing of this session, and we wish all of the best for you. Thank you for all of you. Thank you.
Thank you.
Thank you.
Thank you, Your Honor. Have a good day.